afternoon, everyone. Welcome to Eckstein Hall, Marquette University Law School, and On the Issues. I'm Mike Goucher, and I'll be moderating today's discussion. We're doing this series, as you know, as an effort to talk about important issues in this community and in this region and even beyond. And today we're going to be talking about a proposal that's been made by a judicial task force with the Wisconsin State Bar. And essentially the proposal is that Wisconsin Supreme Court justices should be limited to one 16-year term in office. That would be a change in the way we currently do business in the state of Wisconsin. We are joined today by the 4 Judicial Task Force board members. Introduce them to you. Joe Troy is seated next to me. Joe is a former Outagamie County Circuit Court judge and chief judge, currently a partner at Habish, and Rotier. Seated next to Joe is Catherine Rotier, a partner at Boardman and Clark in Madison. Kathy is also a former president of the Wisconsin Defense Council. Seated next to Kathy is Tom Schreiner. Tom is a commercial litigator and a partner at Foley & Lardner here in Milwaukee. Some of you know, some of our students who are in attendance today know that Tom Schreiner is also an adjunct professor here at Marquette Law School, and he's former president of the 7th Circuit Bar Association. And Christine Bremer-Mugley is with us today. Christine is a plaintiff's personal injury lawyer with Bremer and Trollope in Wausau. She is a former president of the Wisconsin Association for Justice. Let's please give them a warm welcome to Marquette University Law School. So I'll start with Joe Troy. Joe, give us the genesis of this idea. First of all, why do we need to change state law?
Well, let me just first say I am so thankful to have the opportunity to discuss these ideas with you and to discuss them with a group of people that have an interest in the law and, for many of you, a love of the law, which I can tell you is what is in common with the 4 of us. We all love and respect the law. And in our way, we felt like events have unfolded, that conditions have developed in our state and across the nation that has resulted in a blurring of the lines of the separation of powers between the political branches of government, the executive branch and the legislative branch, and the judicial branch, which is by design to be independent of politics and to be beholden to the law, to the rule of law. And that's what was at the core of it. We said, is there a way in these times with the dynamics of elections and the law that exists, is there a way that we can improve the clarity of the role of the judiciary, which is to be the independent guardians of the rule of law and to not be beholden to politics of any kind? And we believe when you have a chance to cipher through all of the different information you may hear about and all the thoughts you may have, that you will likely see, as we have, that there's a way to improve things, and that way is politically neutral. It does not advantage or disadvantage any particular political philosophy or group. And that's where we came up with the idea from all of that as our core.
Kathy Rotier, this is an issue essentially then about public perception of the High Court, is it not?
Yes, largely that, because we were facing a situation where the mission that was given to us from the State Bar is address the concerns that are out there in the public and among lawyers in the legal community about the lack of perceived integrity in our judicial branch, the fact that elections had gotten very nasty, that there was a lot of money at issue in these elections, and the view that the independence and the integrity of judicial decisions couldn't be trusted in the same way. So we were tasked with, how do we improve that? Can we think of something that will move the ball forward and really create a materially better situation, construct than we have now? And that's what we came up with, the single 16-year term for Supreme Court justices.
And we'll talk in more depth about that in just a moment. Tom Schreiner, give me your sense of where we are in terms of Supreme Court elections in this state. Was there a tipping point for you and others on this task force?
Well, I don't know. I mean, it's the past 20 years have been pretty awful in many respects. I think people who care about the court and care about its role, I think, have become concerned that There's just a great deal of nastiness. Certainly, there's a lot of money being thrown into elections, and so forth. To some extent, we can't do anything about that. The Constitution says, I guess, that people can spend what they want to spend on judicial elections like any other election. So when we looked at it, we thought, well, what is there that might be done? There are a lot of studies that have been done around the country. I just heard yesterday, retired Justice Sandra Day O'Connor gave a speech to a group of lawyers in Pennsylvania pushing the point that she's pushed before, which is we've got to do away with judicial elections in the states and make it wonderful like federal, I guess. But not that the process of confirming Supreme Court justices is anything wonderful to behold either. So politics is going to have its effect, but what we thought was that the problem that presented itself, particularly, is that in Wisconsin, it isn't a problem. This is just a fact. We're never going to do away with the election of judges. We thought that was just, let's be realistic about it. We still would vote for dog catchers if they were on the ballot in this state. The people never want to give up a right to elect. And so we started with the premise of, is there something we can do that would actually make things better? And if we're still going to have elections for the Supreme Court, and we think we will, and therefore that's the direction we went, what could we do? Well, we could prevent the situation in which there's re-election for the Supreme Court. That is, we've envisioned a situation in which justices are elected to the Supreme Court in campaigns. People can contribute money. People can say what they think. But once they're in, they're in. Once they're in, we would not have the idea that incumbent justices would be looking over their shoulders to see whether the people who will be giving them money at the next election approve of the way that they're deciding things. And as we thought about it, we thought not only would that improve independence and the appearance of independence, but it should improve something else, which is the whole idea of collegiality on the court. We all know that, whenever an incumbent Supreme Court justice now comes up for re-election, several of his or her colleagues go out looking for somebody to run against them. And how can that help the court function properly in the way that it traditionally did before this current, whatever it is, the atmosphere on the court? So we say, in a way, this helps kill two birds with one stone, improve independence, improve collegiality, and we think that would make a material difference, and that's what led us to propose this.
Christine Bremer-Mugli, this is unique, though. This idea of a single 16-year term is unique in this country, is it not?
Yes, this is, it's exciting to think that in Wisconsin we once again come up with something unique, and this is purely a Wisconsin idea. There would be no other state in the nation that would have one term for a justice. So once elected, under the new provision, you would never be elected again. You would never run again. And so if we look at across the nation at all of the court systems, we have many courts that have the Missouri plan, which is a merit selection plan. We have some states that have life terms for their justices, and some that have elections. Some even have partisan elections. But in Wisconsin, the idea that we have come up with as our small commission, and which we are so happy that the State Board of Governors has really endorsed really strongly, is a plan that's unique to Wisconsin. And so it is one term, 16 years. And so we're really proud of that. And I think when you look at the language, and I hope you all have had a chance to look at the beauty of it, how simple it is, when you look at the language, you'll see that it is a very simple change, but it could have really profound influence on the way our courts are put together in the future.
Let me pick up on the fact that a decision was made not to do a merit selection change. 23 states do it that way, District of Columbia. Why not go that route?
Well,
go ahead.
Well, we kind of we looked at merit very closely, and because there's been a big call in our state for us to look at merit selection. But when you look at the history, and Tom is our historian of our team, but when you look at the history of our Constitution and how this was really debated in the Constitutional Congresses here for Wisconsin, we really wanted to protect the right to vote. And the people of Wisconsin have said throughout that election of our judiciary is very important. We are only the second state in the nation that has had all of our judges to be elected.
An additional point about merit selection that is so often just not mentioned, and I think is a critical part of the equation, merit selection doesn't mean no elections. In every single state that has merit selection, which is some committee that makes a recommendation usually to the governor and then a choice is made, in every one of those states, there are retention elections. They're not given a life term off of an appointment except in 3 states. So in all those states, you do not get rid of elections if you go to merit selection.
And the retention elections look like other elections?
Partisan elections.
Or worse.
And, we looked at Iowa and the experience in Iowa and Florida and California, and in these retention elections, there were very large, very divisive, politically divisive issues before the court. And in Iowa, there was an issue of gay marriage, and 3 judges that were on the Supreme Court were not retained. A lot of third-party money came into the state and greatly influenced the election. Retention elections, even if you have public financing, there is still the opportunity for third-party money. So we really looked at that closely and looked at those experiences and said, that's not the solution if we're trying to get away from really terrible, divisive elections. Retention and merit is necessarily not the way to go.
And one more point on that. You have to have a committee that selects the names that are forwarded to the governor, and the selection of the committee becomes a very political hot potato. So trying to figure out how many people on which side and which political philosophy are going to be part of the committee can itself derail the process and make it a very politicized process.
You raise a good point. Speaking of the committee, people out there in this audience are probably wondering, what are the politics of the 4 individuals here? That was something you actually thought about, was it not, Joe Troy, when this panel was put together?
Oh, absolutely. We knew. I was given the great opportunity to select the other members of this task force, and the one thing we knew is it had to be credible to as many people as possible, and that it had to, at its core, begin as a bipartisan view, or that there had to be perspectives of at least the 2 major influences in the state had to be represented in terms of the thought that we would be engaging in and the perspectives that would be shared. And so we are, in fact, divided 2 and 2 between people who generally would be considered on the left and people who would generally be considered on the right. And
plaintiffs' lawyers, defense lawyers, right?
Right.
That's the great divide in Wisconsin.
Yeah, those of us that represent, the injured, and those from the insurance companies who don't want to pay them. So we had the most spirited and enjoyable debates because of this diversity of general perspective. And what we looked for was that core where all our views intersected. We all agreed on this much. And if we started out with that, we felt the chances of gaining bipartisan support, which is the only way this will happen, were best. It was essential. And so it's been not only a joy to share this kind of high-level thinking and analysis and sharing, but it's going to be a joy going forward as people understand that this is unique in the sense that good Republicans who are thoughtful people and good Democrats who are thoughtful people can agree on this and can understand that it's not a political issue. It's exactly the opposite. It's a way to separate the branches of government so that when a justice is once elected, they never again become a politician for that job. They're just a justice. Their only job is to enforce the rule of law their entire term. We think that's a good idea.
Tom Schreiner, we should make it clear, though, that should there be a vacancy on the court, that the governor still retains the ability to make that.
Yeah, I mean, we didn't want to pick any more opposition than we would have, and regardless of who the governor was, governors cherish the opportunity they get to fill judicial vacancies. Governors in this state fill vacancies on all the courts when incumbents resign or die or go to prison. That doesn't happen very often, fortunately. And so we didn't want to take that on. We really wanted to have a simple solution. If you look at the text of the constitutional provision that we've suggested changing, we just changed 10-year to 16-year, and we say that anyone who's been elected to a 16-year term is not eligible. We took the language from the 22nd Amendment to the U.S. Constitution, not eligible to run again, and not eligible for that. And We accepted from it incumbent justices. This isn't directed at anybody on the court right now. If anybody on the court wants to run for another 16-year term when their current term is up, if this passes, they're open to do that. But we thought 16 years, and people say, well, why 16 years? Well, anything's artificial, anything's sort of arbitrary. But it's a long term. It's 4 governors' terms. It's 4 presidential terms. It's a long time.
And longer than the average.
And longer than the average. And over the past 60 years or so, the average time that justices have served in the Wisconsin Supreme Court has been something like 13 and a half years. So this is a long term. This is something where a lawyer, we're all in favor of having more lawyers on the court, but a lawyer, a judge, can take a look at the vacancy that's coming up, decide, well, I'll put myself and my family through the agony of an election once. I see Professor Falone out in the audience. You know what we're talking about. We'll go through that once. And if I get it, I'll know how old I'm going to be when that time is there. 16 years is a long time. It's enough time to have a good, strong, positive influence on the court. But when you're there, you're a justice, you're a judge. You're doing your job of applying the law. You're not looking over your shoulder to see, well, who's going to donate to my next campaign? Who am I going to annoy if I vote this way on this decision? You can just spend your time being a judge, and that's what we want.
Here's my question. It doesn't remove money, though, from the equation, does it not? We still have elections, so we will still have spending. We will still have outside spending. Right. There's really no way of addressing that, is there, unless you just say...
Unless you want to repeal the First Amendment, right. Which we're not in favor of. But
it was an example of why we wanted to be pragmatic about what we can change and what we cannot. Just like with the appointment power, we made a decision early on that governors really cherish this power. We're not going to mess with that. And so we stayed away from that. And when we looked at the issue of the Citizens United and the decisions that have come down that govern our courts and the election laws, we knew that was something that couldn't be changed by a proposal from a commission appointed by the Wisconsin State Bar.
So when Mike McCabe from the Wisconsin Democracy Campaign says you should be focused on campaign finance reform, you're saying that's not going to work because of what the courts have ruled on this. Is that essentially it?
Well, not in the near future, shall we say.
If we want to make a change that at least the young lawyers and the law students among us can function under that system, we had to go someplace else because that kind of radical finance reform in elections wasn't going to happen within that time period, whether it was a good idea or a bad idea. But I think it would be unfortunate to not at least see that when you talk about not being able to remove money from a judicial selection, we do for those that get elected, they're done. They're never raising another dollar again. Once they get elected, they don't have a campaign, so they do not have to have people on their behalf go to the moneyed interest in the state to support their perspective through that campaign. And just one final thing to think about. In 103 years, there have been only 2 justices who sought re-election in the state of Wisconsin who didn't get it, only twice.
Who've been elected to a full term and then sought re-election.
So Louis Butler, for example, the most recent, he was not elected. So we're talking about those once elected. When their term comes up, historically speaking, it's a virtual win, all but twice in over 100 years. And one of those has a very interesting background, which kind of explains how it happened.
Well, he supported moving the Milwaukee Braves to Atlanta and had the misfortune of coming up for re-election the next year. And he got beat. And actually, that was the last time this sort of subject of what can we do about politics and its effect on elections came forward, because shortly after that, Chief Justice Hallows, former professor at Marquette Law School, who was on the court at the time and very upset that his colleague, Chief Justice Curry, had been defeated. He was a very good judge by all accounts. Persuaded then Governor Pat Lucey to appoint a commission and to look into judicial reform and reorganization, part of which led to the creation of the Court of Appeals and so on, things that happened 35 years ago or so in the state. But one of the proposals was to have a retention election in Wisconsin, to have a merit selection process in Wisconsin. The commission came up with this recommendation, and the public reaction to it was just, you're not going to take away our vote. And indeed, it was the AFL-CIO who said, we'll kill the whole reorganization of the court system if you put that in it. So it came out.
There's a poll that shows that in Wisconsin, 70% of the people polled said they wanted to elect their judiciary. So it is this tension between accountability and wanting to have our judges accountable to the people, and yet independence that we all really cherish. So by doing it this way, by having one 16-year term, we think we can meet both goals.
Kathy, it looked like you wanted to weigh in there.
Well, I think there's one more thing on the financing. We really don't know how it will change the whole financing dynamic to have an election for a 16-year fixed term, because frankly, you don't know what you're buying. I mean, you don't have that person beholding to you for the next re-election, right? So you may want to support, and support strongly, which is fine. This is America, a person of the same political philosophy that you are. But once that person is elected, then that person gets to do the work of a justice, deciding hard cases in the way that hard cases have to be decided, whether the result is popular, whether the result favors the organization that may have supported your candidacy in the first place or not. So I think there's a great freeing aspect of this whole fixed term. And a person, whatever their age, whether they're late 30s, early 40s, 50s, and they decide to make a go of this, that is a huge commitment, but it's a one-time commitment to put yourself through the sausage mill of an election and then have this block of time to really develop the law, develop a legal legacy, and, create something and really return our Supreme Court to its glory, the former glory that it always has had.
Let me pick up on that, on something you just said. You were talking about the age of people who might run for office. And I guess the question I have is, does this become a job that is largely filled by people at the end of their legal careers, where they see this as sort of, this is the final thing I will do? And does it draw a certain kind of candidate rather than somebody who's 35 years old?
And we don't want a 35-year-old Supreme Court justice.
Not enough accumulated wisdom.
Not enough accumulated wisdom. You got to practice law or have people appear before you for a while before you do that. I think that'll sort itself out. We've had Supreme Court justices 40 years old. There's nothing that would keep somebody from running when they're 40, serving till they're 56. It'll look good on your resume. When you go for your next job. But we assume that one of the consequences of this might be to have people actually wait until they have accumulated some wisdom and some experience of life, run when they're 45 or 50. I don't know. Who knows? But the point of it is, there's no great hardship to say to someone, after you've served 16 years, do something else. A lot of people do that nowadays, right? You're on at least your second career, aren't you, Mike? And people do that.
Point taken.
People do that, and I don't think that's a reason for opposition to it. It's a good long term. It's a time to really do some good work. People would have to. I assume when people run for office, they take it seriously anyway, but they'd have to think about it, and they think, this is a long commitment, and particularly in Wisconsin, because once you're elected to a 16-year term, you don't have to fill out the term, but you can't run for any other political office during that 16 years, because that's a provision in our current Constitution. You're ineligible for any other position under the state of Wisconsin during the term for which you're elected as a judge.
It's interesting because some of my younger friends have said that they're sick of the baby boomers running our country and look at the mess we've made of it. And so they'd like to have an opportunity for some millennials to maybe run for something and win. And one of the things that we really thought about was, will we attract different candidates to run for the court? We've been blessed with really great candidates like Ed Falone, who ran, and others, but it's hard to run. It's a huge sacrifice, and with this kind of a new system in place, maybe more people will want to run. Maybe more people will take that chance. So we're hopeful that it won't always be the same kind of people, and it will maybe attract others.
And at the end of terms, right now, you have to decide, if there's an incumbent justice that comes up for re-election, that's a formidable opponent. We know historically, right? Because they win all the time, except in very extraordinary, exceptional circumstances. Whereas under this plan, when a person is at the end of their term, it will be two people that have not served on the court that will be having the election. And the chances then of more people saying, well, I got a shot at this, I might have an opportunity here, you would think that that's logical, that there'd be more people feeling like they have a chance. Because if you analyze the politics of beating an incumbent justice that's been there for now a full term, that's a formidable thing to do.
What's the reaction you're getting as you begin the rollout of this idea? I mean, the Board of Governors signed off on it at the end of September. What kind of response are you getting from the legal community? What kind of response are you getting from the general public? Kathy?
I think, first of all, we're thrilled that the Board of Governors overwhelmingly supported this. So that is a great thing. So now we can go out, the four of us, this little road show that we have here, and be the voice of the State Bar, which is great. And it's an opportunity for the State Bar to do something really meaningful, which is another very important aspect of this. But you asked me what happens when you just describe the idea to people. I think an initial reaction is it's too simple. But that's the beauty of it.
Too simple.
The simplicity of it is what makes it work, because it's not pro-left, pro-right. It's not in favor of one ideology over another. It is a good government idea. That's really what it is. And this whole Wisconsin idea that we're trying to promote is that, we were the laboratory of democracy during the progressive era, and we were the state that came up with workers' compensation and with ideas that have taken root and grown all over the country. And we can come up with an idea like this that will work. So when people say it's too simple as an initial reaction, then ask them to please read the report we prepared, and please think of how this would make a difference when you don't have a sitting justice opposing the re-election of a colleague. Wouldn't that help collegiality? Wouldn't that be a wonderful thing? It just has many, many ramifications from what is a blessedly simple idea.
Tom and Christine, how do you want to see this proceed? I mean, you have to change the Constitution, so it needs to pass in a couple of consecutive sessions of the legislature. How do you see this moving forward?
Me first?
Sure.
I want you all to recognize I wore a red suit today just because I thought you guys should know I'm not just only a lefty. I'm wearing a red suit. So she's wearing, and he's wearing a blue shirt. So, one of the things that we think is really important is that we bring all the lawyers together. That's why we're so thrilled to be invited to your law school today.
And if I interrupt just to say, this is really, and I mentioned it earlier on, this is where this started from. This started from disgust, frankly, on the part of lawyers throughout the state on every side of the question imaginable at what they saw going on with the court. And their demand, when people ran for election to the state bar, their demand that the bar do something about this.
That's right. So for the bar to come forward and empower us as a task force, we were very worried that our work would not be concrete or meaningful. And that was so important to Joe as he led us through this. When we'd go down a path, he'd say, let's go back to where we should be. We want something to be meaningful and to really happen. And so now the state bar has taken it forward. And we were so thrilled for the great vote that we got from the Board of Governors. And all of you know, if you've had any experience with the Board of Governors, they're not the group that's always really happy and singing together about everything. And so when they came together on this, representing a divergent group of lawyers from across the state, we were thrilled. So right now, what are we going to do? I'm going to the trial lawyers in December at our meeting here in the Pfister, and I'm going to explain it to them. Kathy's going to go out to the defense attorneys, and she's going to talk to them about this idea. We're all going to go out. We have other members now. The president of the board of the bar has appointed others to our committee who are likewise going to go out as ambassadors to discuss this idea with the lawyers first. So we will not have something pass in a month that nobody's really talked about, but we will have something that has been thought about for 2 years, studied hard. We've really done all the work that we can do in terms of the academics of this. And now we're going to go to the people, and first to the lawyers first. And then we're going to go, with the support of the bar, we'll go out to the communities and to the politicians. But we want this to grow from the lawyers out, and that's how it started, and that's how it will grow.
And I'd only add when Chris says lawyers, we of course include judges across the state. And,
Judges used to be lawyers once.
And that's right. They occasionally remember
Some of them
that.
become lawyers again.
And but we think it's the legal community that has the biggest stake and responsibility to try to make a positive change. So that's where we're beginning.
Does it hurt when the Chief Justice says she doesn't think she's in favor of this?
Well, that's not what she said.
What did she say?
No, she didn't say that. She said that she would like it to go a bit further, and she would like to see some rules on discipline, and she would like to see some rules on recusal. But that was not our task. And when you think about recusal rules under the current system with Citizens United, even if a judge does receive money from someone and you know that, there's no transparency with regard to third-party donations. And so recusal rules, until we get Citizens United fixed, really can't be implemented in any meaningful way. So, that wasn't our task. And so I don't think the Chief Justice has said she's absolutely against this. I think what she said is, wouldn't it be nice if we could do a little bit more?
When do you approach lawmakers about this? How will you approach lawmakers about this? Because you've got to find people. I think this is one of these where you have to find people on both sides of the aisle
Right.
who are going to support this.
That's our view of it.
Yeah.
Well, that's why we're trying to work from the grassroots. I mean, ultimately, constitutional amendments in this state have to be approved by the people. They have to go through a couple of legislatures, yes, but then they've got to pass a referendum. So what we're working to do, starting with the lawyers, because those are the people we know, lawyers tend to be well-respected citizens in our local communities. And so what we're doing is starting with the lawyers, hoping thereby to influence the people, the voters, ultimately elected representatives, to persuade them that this really would be a good idea. This really would be an improvement. And that's all you can do. I mean, all you can do is take a look at what's happened over the years and say, if we were to change this, we think that we would eliminate this problem, and that would be better. So that's how we're going about it. We don't have a big advertising budget. We're not going to go on TV. It's a little early for that. But we're not going to go on TV with it. We're going to try to persuade. I mean, that's the way democracy is supposed to work, isn't it?
There are few important pieces of legislation that don't have a pretty obvious bent one way or the other, so that you're getting support for it, and from that perspective of whichever side it tends to be favored by is pretty easy. What we need to do is to have the kind of conversations with the leaders in the legislature that we can get beyond the partisanship of it. And that we know it is going to take some strategy to put us in a position to sit down and talk and listen, and thereby, in our view, gain enough of the key people that we'll need, because they'll see that it's a meritorious piece of public policy that would benefit the citizens in Wisconsin, and they don't have a good reason to be against it. That's what we think will develop, but it's a lot of work, and we're looking forward to doing it.
So the process for this is different, let's say, than what happened recently in the legislature, where you had a move that would change the way the Chief Justice is selected. That moved through very, very quickly, at least, in the first of the process.
The first of the two legislatures
Exactly.
that it
But
has to pass.
this is a different animal, is really what you're saying.
Right. It's a different animal. Whatever the motivation behind that was, I thought it was interesting. The local newspaper yesterday had an editorial saying, well, whatever the motivation was, and we don't think it was a good motivation because it was pretty clearly aimed at the current Chief Justice. It might be a good idea. Now that it's passed the Senate, we think when it comes up in the Assembly, we should discuss it. But the paper seems to have missed the fact that it passed the Assembly 4 days earlier. So it's sometimes public policy gets discussed that way, and sometimes you get more time to talk about it. And this is clearly a proposal that the one we have that is longer term, longer range. It's interesting, the motivation. I mean, the proposal to change the term of the Chief Justice, the Constitution currently provides that the longest-serving justice is the Chief Justice, period. The proposal that went through the legislature for the first time last week was to change that to an election every couple of years. if that passes, that's compatible with what we're doing. And the two are not inconsistent. It's just a different issue. But it's interesting that if our proposal were to pass, one of the things that would come about would be you wouldn't have anybody serving. How long has the Chief Justice been Chief? You wouldn't have anybody serving that long a period of Chief Justice because you basically only got 16 years. And by the time you become the senior justice on the court, you've probably been there 10 years. So we're probably talking about 4, 5, 6-year terms of Chief Justice just under the current Constitution. So
I'm going to wrap this part of it up, but I'll ask each of you, just the final question is, how disappointed would you be if this does end up being one of these reports where a lot of good, well-intentioned work went into it, but nothing came of it? How disappointed would you be, Kathy?
Very. We've worked really hard. I call this a traveling roadshow. I feel like that's what we've been doing, and we've been meeting for well over a year and a half, put together a report where we really tried to think through the issues and think, is this too left-leaning? Is this too right-leaning? How do we know we've got a good government proposal here? And really worked hard to try to find something that wasn't goring anyone's ox, that was really something people could get behind. And that's what we need to find in the legislature. Somebody on both sides, Republican and Democrat, who would be willing to say, yes, I will support this and I will move this forward through the legislature because it's a good piece of legislation. But very disappointing if somehow that people said, oh, you know, nice idea, not so thrilled, put it away. And then nothing more gets done, and then we wait for the next really contentious, really mean-spirited election, and we say, oh, we've got to change this. This is horrible.
Are the others optimistic in this group? Are you optimistic about the 14?
Well, you ought to be optimistic about the prospects of a good idea getting adopted. I won't be disappointed if it gets a full debate and the people don't like it, because that's how policy gets made in this country. I will be disappointed if it never sees the light of day in the legislature, but I don't have any control over that either, so I won't cry myself to sleep at night.
But I think
there are always more important things going on in the world.
Well, it's
right?
no kidding. But I think that all of us, there are so few lawyers in the legislature right now. Maybe you don't realize that, but there used to be filled with lawyers, and now there's like 4. So what we need to do is, all of us lawyers that really believe in it, we all know our legislators, and they don't understand a lot of these things, and they call you, and they say, what do you think about it? And so that's why we want the lawyers to know about it and come to us with ideas or debates and let us know what you're thinking, because you will have a huge say in this. And so we aren't going to talk about being disappointed, Mike. We're going to talk about what's next. Right. And so we don't want to say there's not about disappointment. This is about let's make this happen.
Joe, you get the final word here.
Well, I am a trial attorney, and like all trial attorneys, regardless of what side of the fence they may practice from, I never really lost a case. There's some other explanation that I can come up with to keep it going to the next one. And so if it would not pass in our timetable, I'd be optimistic that down the road the wisdom of it will come to the fore again.
But a good idea is a good idea.
That's right, and it will be time perhaps or some modification that will do it. And I would just close with saying, honestly, maybe we would express it differently, but I know that we all feel that, as my dad told me many times, do the best you can and then to hell with it. We're doing the best we can.
Let's take some questions from the audience. Just raise your hand and we'll try and work our way all the way through the room. Yes.
Joe, you mentioned 2 candidates. If this comes to fruition, will indeed there be a limit on candidates?
Oh, no, because we don't change anything about the Constitution with respect to elections. So therefore, if there were more than 2, there would be a primary. And then there would be 2 at the end, just as there is now. We don't touch it. So, yeah, there could be perspectives from all over.
Mm-hmm. Yes, sir.
Kind of a 2-part question. Who are the people or what are the entities that you see as having a vested interest in preserving the status quo? And then what is the strategy for addressing and overcoming that opposition?
As part of the optimism that we feel, I don't know that there is anybody who's got a vested interest in the status quo. Both sides win elections to the Supreme Court. During this time that I've been talking about, when things have been going on that we haven't cared for, both sides have won. So basically, a lot of that has been re-election of incumbents. So maybe the people who favor election of incumbents because it's easier may think, well, this won't be as easy to handle in the future. But I don't know. That's that's too far away for me to figure out. I don't know that there are. I don't know why there would be vested interests.
Anybody else?
Well, I would just like to say I think that it seems to me that the persons with the vested interests are the persons that carry the majority right now, especially because of this very issue of the difficulty of unseating an incumbent. So if that's the case, then we'll have trouble with it. I think, though, that everyone, when they look at this closely, will see the beauty of it and hope that in the future this could change some of the rife that we've had in our court and change the nastiness of these elections.
Sure.
I have two questions. One is practical and the other is political. Wouldn't the moneyed interest jump at the chance to have this be the law? Wouldn't you rather buy a justice for 16 years than for 10 years?
How do they stay bought?
Yeah, that's,
I mean, that's the issue, really.
yeah.
You know, you've got somebody in for 16 years. You think you bought them, you put them in.
Right.
Well, besides the fact, if you're a person or an entity that has the resources to impact an election because by funneling it to one side or the other, then you are certainly smart enough to look at the fact that when you elect a 10-year justice under the present system, you've elected them forever, because they're not going to lose a re-election in all likelihood. So to the idea that there would be front-loaded money because it's 16 instead of 10, I don't see those kinds of interest groups really thinking beyond the next one or two election cycles, in making those kinds of decisions. And the reality is, when they support somebody under the current system and they get them elected once, they're assured they're done. So there's a lot of incentive right now to just get them in there because they won't be able to get them out.
But there's also evidence from the Emory Law School did a study, and there's empirical evidence when they studied the decisions of judges who were going to be subject to election versus those who were going to retire. And it was evident from the decisions that those that were going to retire did not vote in a political way, and they voted in a more independent way. So if we look at what the studies have shown, that the farther away you get from your election, the more independent you become, I think that there's real hope for this to be a start for a true independent judiciary.
If I could just follow up a little bit on Joe's point and for the response to that question. Incumbent justices who've served 10 years tend not to get defeated, and it's happened twice in the last century. So who are the vested interests out there? Maybe they're the people, and they're on both sides, who run campaigns and raise money, who are out there saying, let's get rid of Justice so-and-so. Well, it isn't going to work, but in the meantime, there's a lot of money that can be raised and money that can be spent, and percentages of ad buys that can go to people who run campaigns that maybe keeps this going, that we might just do away with. But that wouldn't be a bad thing.
Yeah, I agree with that. I have one practical question. I don't know anything about the judicial pension system. Is there any advantage to working for 20 years in the current system to become vested?
Joe knows all about it.
Joe knows
Because
it all.
he
Would
spent
the
his whole
16
career
years
in the
be a
pension.
disadvantage, a disincentive because you'd be missing 4 years?
The fact that I was a trial court judge for 20 years and 1 day, no, there's no difference. Under the present system, it's simply a formula, the number of years times a multiplier, and so there are some very marginal differences, nothing that would influence a person to run or not run. Some life insurance differences, things like that.
Somebody with a 16-year term is going to have a fully vested pension from the state at the end of that term.
And they're going to have such an excellent credential that they can name the tune after they're done. So,
Let me go right here. Hang on one second. Thanks, Ryan.
I just wanted to clarify something. If I understood right, one of you mentioned that the average amount of time that the justices are in is 12 to 13 years?
13.4, something like that.
And yet you're talking about a 16-year term?
Yeah.
So does that mean when people leave after 12 or 13 years that then the governor would be appointing?
The governor would be appointing, because that's what the Constitution provides, and we don't propose to change it, anytime somebody leaves before the end of the term.
Exactly.
Now,
that's why I'm questioning the
what
amount of
tends
time
to happen,
you picked.
What tends to happen under the current system with 10 years, and how did that 13.4 come to be? Well, we've got people who serve 20 years, we've got people who serve 3 years, and then got appointed to the Seventh Circuit or something like that. So We don't propose to change the governor's power to fill vacancies by appointment. That leads to an election at the next opportunity when there is no justice whose term is expiring. That appointed justice has to run for a full 16-year term, as it is now.
I can't justify that.
Okay, so I just want to make a point. Maybe it's helpful. Maybe you already appreciate this, but when there's a vacancy before the end of a justice's term, the governor appoints. Then
I understand.
Then that person must run in the next April election. They don't serve out the term that what was there before. They only have probably under this system about a year. So there would be, in that sense, an incumbent running, but only a person that had been there on an appointment for a very short time, not somebody that had been there for 10 years. And that doesn't change, except that...
Well, what was your concern, though?
You don't fill out the unexpired.
If a justice leaves before the 16th term and the governor appoints them, they're only in for a year and then there's an election?
The rule is that if there's an open election that next April, then that justice stands for the election at that time. If there would be one other member of the 7-member court who was up, then that election, because you only have one election per year. So there's a chance that you might have
a couple years before there's an election in regard to that vacancy.
As it is now.
I don't support that.
Okay.
That's what we have right now. That's our system now.
Other
so
questions?
Justice Butler went a little bit longer.
Raise your hands. Sure.
So is the idea that every 2 years we'll get a new justice, or every 16 years we'll get a whole new court?
Oh, no. No, it's not. It would not be all a turnover in 1 year, for sure, because it's going to be, in fact, the staging of elections or the space of time between elections will grow. So the frequency of elections is going to be reduced. That's one of the benefits of the proposal, because we've been so stung by these very divisive and nasty and expensive elections. This will reduce the number of them, and it will create, I think, an easier flow, a greater consistency, and we probably won't have people retiring or leaving after 13 or 14 years when they know they've got a fixed 16-year term. I would think they would fill that out in a way different from what we have now, just because it's the expectation.
We do expect over time, if you divide 7 into 16, that we'll have, on average, a new justice every 2-point-whatever years it is. That is part of the plan.
Mm-hmm. Yes, go ahead.
I'm just curious how your process to come to the current plan evolved over time. It sounds like you've been working on this for some time. Was it always 16 years? Was it always just one term? Can you describe that? I'm just curious how it went down.
Why don't you do it?
Well, I would. We started with studying what's out there now. We looked at what every other state does in the federal system, and we looked at all the other states that have done similar studies because the U.S. Supreme Court's decision have affected elections all over the country. The effort of appraising whether there should be change is going on in other states. So we just started fact gathering, and we just started understanding. And then we turned to the history in Wisconsin of our present system so that we understood how it's been working, how it's been operating. And we evaluated then all these different systems that states have deployed and tried to look at the positive and negatives of those. And then we all woke up one night and we had an amazing mutual experience of saying, how about a 16-year term? How would that work? And it evolved that way through thought and study.
One of the points that I would make on that is in the beginning stages when we were just getting our feet wet in this and we were looking at studies that had been done in other states, because this isn't a problem that's unique to Wisconsin. And there's a very nice report from Michigan. There's a very nice report.
Paper, right?
Yes.
When you get the dust off of it.
From Minnesota, and I'm a very practical person, and you ask me to put a lot of time into something, I want something to come out at the other end that means something, and not as just another glossy report that's going to sit on a shelf and gather dust. So we were very pragmatically driven to find an idea that would hit the sweet spot and that would not be no one would have a reason to be adverse to it because it isn't going to hurt their interest. And so that's the whole practicality of this approach is what motivated us pretty much from the early stages of our work.
Yeah.
Tom's comment a little while ago about you can try to buy a justice, but he or she won't stay bought, got my attention. I came into this room totally agnostic, and you guys have persuaded me, but that's not the point.
Good, yeah.
What
Persuaded you what?
Yeah, which way?
intrigues me, and maybe you've all thought about it, but I haven't heard it said in these words, is that running for one 16-year term where you cannot succeed yourself in itself, I think, is going to drive away a lot of the big money that has come into this state.
I think so, too.
Unions on one side, Chamber of Commerce and business interests on the other, because they won't be able to even come close to guaranteeing a justice who is going to vote 95% the way their interests lie. And I think that'd be a fabulous thing for the state of Wisconsin to reduce considerably the impact of big-time, largely out-of-state contributions.
Bill, you may be right. You may be right. I don't know. I mean, we obviously don't know that. But one of the things that when it was a joke when I said, will they stay bought? But the question really is, who runs for Supreme Court? And we had some discussion about, whether a different group of people might be interested in the job. Maybe a wider group, maybe more lawyers. I was serious about that. I think trial lawyers make pretty good Supreme Court justices. But it does strike me that people who get to the point in their career where they're going to run for the Supreme Court have thought through a lot of these issues. And they're not going to switch overnight. If they're conservative, they're going to be conservative. If they're liberal, they're going to be liberal. Whatever that means to a judge. Ideally, they're just going to apply the law. But as you know, particularly in a state court, a state Supreme Court, it isn't just interpreting statutes and construing the Constitution as it is in federal courts. State Supreme Court justices deal with the common law. They deal with the law of contracts, the law of torts. There is more legitimate lawmaking that goes on in a state Supreme Court and in this Supreme Court. And so it'll be interesting to see it unfold. But I don't think people change colors overnight. I think people come in and that may be freed by the idea that they've got 16 years to serve and they're never going to be eligible for re-election. But I think people are going to be pretty careful about who they support and who they vote for. I think people are still going to be thinking just like they do when they vote for governor or the legislature. You're serious about it. I think people will still be serious about who they support for justice.
Two names, Tom: Earl Warren and David Souter.
What about them?
About changing their...
Warren was always that way.
Don't goad him; it just gets worse.
This sounds like a familiar beginning to a discussion we've heard. I would suggest, though, that while a person would come to that position with a particular experience and perspective and judicial philosophy, that the public perception of whatever individual decision they would make, at least they wouldn't say, oh yeah, the guy's up for re-election, she's up for re-election in the next 2 years. Look at she or he just favored this side. The perception that they are driven that way would be, I think, diminished by the idea that no, they're not going to be asking those groups for any support or money again.
And that's really important. I mean, that's once the public perception is that the judges are just like legislators and that they vote the way they've been told to vote by the people who put them in office, we've lost something so valuable. And so that's really what's, I think, driving us. The public perception is reality.
Mm-hmm. We have time for a final question or two. Yes.
If the idea is that you don't want justices looking over their shoulder or looking for where their next election money is going to come from, then why, or rather, did the committee consider creating language that would make justices appointed to the bench to fill out a vacancy ineligible for election. In other words, it's really the point that was raised earlier. You've got somebody who gets appointed to the Seventh Circuit, or maybe they've got family issues and they don't want to be going to Madison all the time. They say, I don't want to be a justice anymore. The governor appoints their replacement, and then they get to stand for election. So they've got the problem that you say this proposal is supposed to eliminate, which is that they're going to have to go out there looking for money, and their votes on the court are going to be influenced perhaps by what their future aspirations are.
I think the problem with that is you would truncate very severely the people who would be willing to be appointed, because you'd be talking about being appointed for such a very short period of time until the next election. So maybe it's for 1 year. Are you going to drop out of your law practice or your judgeship or whatever it is you're doing in life for a 1-year appointment where you really can't make a mark because you don't have enough tenure? You're just learning where the bathrooms are, and you don't have enough time to develop the legacy. So I think that would it would not work. It would create a problem with the appointment issue.
The other point, we didn't consider that particular idea. How did we miss that one?
I don't know.
But we did look at historically, is it also true that people who are appointed to the court inevitably win that first election? And what we found is that, no, they are definitely more vulnerable than anyone that has once been elected. So the dynamics and the power of that short incumbency is not the same. And also, it's a practical reality that we tried to factor in here. And when you remove the power from the executive branch, along with this change, well, we'd be talking about it at another forum in 10 years, but we would be no closer to having a law.
And we think that would be true whoever the governor is. I mean, the governors would not support giving up their ability in the Constitution to fill vacancies. So we didn't take it on. Everything's a trade-off. This isn't perfect. This isn't pristine, but it's a lot better.
It sounds, though, that what you're really talking about is term limits.
A term limit, right, a 16-year term limit.
Right, which is a little bit different from the way that it's been discussed earlier, I guess, because there are other options. I mean, did you consider that perhaps the power of appointment for the governor would last through the end of the term of the person who's leaving?
Yeah, that's sort of we did, because we basically rejected the idea of what do they call it, where we have a retention election and a merit selection system. I mean, that's basically the way the merit selection system works. We didn't think that's any better. It doesn't work in practical.
And I think it's really, really crucial that you understand how hard we debated the issue of the governor's appointment power. Right. There are members on this team that have served governors and have worked hard to get appointments, prepared for the governor. And we know how much they dearly treasure that. And so if you start messing with the governor's appointment power in any way, this pragmatic solution becomes dead in the water. So we did not take that on because, as we've said, we want to be concrete and we want it to be something that's pragmatic and that's something that will really happen to make change occur.
See Alan in the back.
Mm-hmm. Yeah.
Did you give any thought to moving the Supreme Court elections to the fall of even-numbered years when turnout is way higher?
We did. Now, that, too, is a provision that is in the Constitution, so it would be another change. And we decided we didn't want to go there. The history of Wisconsin, the idea of not having judges up for election at the time of the general election is part of our tradition going back well over 100 years in Wisconsin. And, there's something to be said for having it at a high turnout election. There's also something to be said for separating it even farther from partisan politics, which has always been, I think, what has motivated the provision putting the elections in the spring. So we thought about it. We thought about most of this stuff, but we decided we didn't want to do that.
The merit of that is certainly a worthy debate. Because on the one hand, you would have a greater percentage of people weighing in. On the other hand, you have removed the last vestige of a nonpartisan judiciary, but beyond that, quite frankly, even if we believe that that was an improvement and the idea that more people would weigh in on the vote, if we had included that change, we knew, just like messing with the governor's appointment, that it would go nowhere. That had such strong political opposition that it's one of the things we had to weigh and say, what can we do? What can we accomplish? And we did cipher that through at least a crude political analysis, and that one was very clear.
I'm going to wrap things up there. Seeing Alan Borsuk ask the last question reminds me that I should mention that on Thursday night here at the law school, Alan has put together a great conference. We're going to be looking at, it's an education-related conference. I know a lot of people in this room are interested in education in these parts, and we'll be talking about open enrollment, Chapter 220, what's happening in other parts of the country to deal with some of the rather large achievement gaps we have in this nation. I also want to mention we have one more on the issues event. It's coming up on December 4th. It's part of our author series that we do here at the law school every year. The author this time will be Craig Stephen Wilder. He's the head of the MIT History Department, and he's written a book called Ebony and Ivy. It's a provocative look at the origins of some of America's greatest universities. We hope you can join us on December 4th. That'll also be seen on public television, we should say. But having said that, I want to thank all of you for your time and attention today. I also want to thank our guests, Christine Bremer-Moogly, Tom Schreiner, Kathy Rotier, and Joe Troy. Thanks very much for being with us.
Thank you.
Great to see you.